Hello and welcome to the Sidebar, presented by True Crime News, taking you inside the courtrooms of high-profile and notorious cases from across the country. I'm your host, Joshua Ritter. I'm a criminal defense lawyer based in Los Angeles and previously an LA County prosecutor for nearly a decade. You can find me on all social media at Joshua Ritter ESQ or at joshuaritter.com. We are recording this on Wednesday, October 2nd, 2024. In this week's episode, New York's mayor has refused to step down after federal bribery indictments, with his attorney claiming that the, quote, perks the man received did not sway his political favor. Plus, an unsuccessful appeal by Hannah Gutierrez-Reed's defense after her conviction in the fatal Rust on-set shooting. But first, the latest emotional outburst in Young Thug's RICO trial as the judge leaves the courtroom in frustration after scolding prosecutors yet again for misconduct. Today, we are very happy to be joined by Neama Rahmani, an attorney and legal analyst you can catch on many different news outlets. Neama, thank you so much and welcome back.
Josh, thanks for having me. As always, excited to be back.
Absolutely. We appreciate you. Just so everybody knows, Neama kind of stepped in for us at a little bit late, so we appreciate him being here, but he is such a pro and understands these cases so well that we knew he would be a great contribution to our discussion here today. So let's go ahead and jump right in. As a rapper's RICO case teeters on the edge of a mistrial, prosecutors in the case have once again been criticized by the presiding judge. Young Thug, born Jeffrey Williams, is the key defendant at the center of a sprawling prosecution alleging that his record collective, YSL, operated as a criminal organization. The trial, which is already the longest running in Georgia's history, has faced numerous delays, including combative witnesses, a judge's recusal, and multiple allegations of misconduct leveled against prosecutors. In the latest head-scratching move by the state, prosecutors were allowed to use a document as evidence in their questioning of a witness, which Williams' defense objected to as hearsay. But the judge gave strict instructions that the document could not be used to authenticate anything. The deputy district attorney then proceeded to use the document multiple times before asking the witness to connect a phone number from the document to a defendant in the case. Judge Reese Whitaker, who has tried to get the trial back on the rails, was so flummoxed by what she saw as a deliberate violation of her order that she had to take a recess after an impassioned denunciation of the attorney. We have some video of that we can show to you now.
I can't figure out what it is. If it's disingenuous, if it is that, I don't want to malign the prosecutor standing in front of me right now, so I'm not going to say the possible things that it could be, but it is baffling to me that somebody with the number of years of experience that you have, time after time after time, continues to seemingly purposefully hide the ball to the extent you possibly can for as long as you possibly can. And I really don't want to believe that it is purposeful, but honestly, after a certain number of times, you start to wonder how it could be anything but that, unless it is just that you are so unorganized that you are throwing this case together as you try it.
As tempers reach a boiling point, Judge Whitaker again denied the defense's request for a mistrial, but emphasized that prosecutors need to be upfront and forthright for the duration of the case, which still has no immediate end in sight. Neama, I don't even know if I can ask you this question. What is going on here? But more importantly, do you think that a case can get so messed up and the prosecutors can have so many little mistakes that finally a judge just says, we're done here and I'm just declaring a mistrial?
Certainly the answer is yes, Josh, but as you know, and we've been talking about this case for years now, it's been botched. You can't charge this many defendants at once. And, I don't know what Fonnie Willis is doing there in Fulton County, Georgia. We've talked about it in the Trump case, where now we're talking about it with YSL. It just becomes too unwieldy. Every witness gets cross-examined by a half dozen or more defense attorneys, and it really grinds the proceedings down to a halt. I know prosecutors love RICO. They like to charge everyone, throw in a lot of defendants, a lot of charges, a lot of predicate acts, lots of prior bad acts, get all this in. But after a certain point, it becomes too unwieldy. And we've talked about all the issues in the case, both inside and outside the courtroom, right? But now this is just another issue. And I think there is a hesitation right now for the judge to declare a mistrial, start all over, because jury selection took so long in the first place. And there's just hesitance to really start from scratch. But like you said, just turning to the issue at play, there are sometimes evidence that comes in for a limited purpose, or in a case like this, you can use pretty much anything to refresh a witness's recollection, but it doesn't come into evidence, right? The witness needs to testify himself or herself based on the recollection. You can't use what's in the document. So this is evidence 101. We all learned in our first or second year of law school. Prosecution should do better, because even if there is a conviction here, Josh, there's so many issues on appeal that I don't know if it'll ever get resolved.
Yeah. You make a really good point, and it brings me to another one of my questions. But this idea of using a document to refresh memory, or using a document for a limited purpose, is not something that trial attorneys are not inexperienced with. They deal with this all of the time. So for this prosecutor to deliberately try to violate the judge's order to try to use this document for the explicit purpose that the judge said don't, it raises either the question of, is she incompetent? Or, as people are starting to say, does it look like they're trying to throw this case into a mistrial? Do you think that they would be that diabolical to try to intentionally encourage or invite a mistrial?
I mean, hopefully not. You're a prosecutor. You and I were both prosecutors. You want to do the right thing. It's not a win at all costs. Not to say defense lawyers aren't held to the same standard, but you're not supposed to backdoor evidence in like this, things that aren't admissible, potentially prejudicial, or something that don't really follow the rules of evidence, right? We all know what hearsay is. If a document is hearsay, it can't come in. I mean, period, unless it's non-hearsay or subject to some exception. So, I don't know what the prosecution is doing in this case. I'm sure they're not happy with how the case has progressed. Many of their own witnesses have gone completely sideways. There's been some terrible law enforcement witnesses. I'm shocked anyone is still following the case that's in that jury box, because, again, it's taken so much time. So the question of, are they intentionally trying to throw the case to get a do-over? I don't know. It certainly would be better for the prosecution if the case started all over, but obviously jeopardy is attached. So unless the defense requests and the judge grants a mistrial, they're going to have to proceed with the case they already have.
Yeah. And to your point, when he talks about how unwieldy this case has become, folks, the prosecutors intend, their announced intention is that they still plan to call an additional 100 witnesses after the 70 that have already testified, meaning in their view, they're not even over halfway through this case yet, which is just mind-boggling to me, because like you said, at a certain point, you would imagine that jurors are just going to start dropping like flies in this whole thing. And it might get to the point where they just cannot finish this trial. Have you ever seen something like that before?
I haven't seen something like this. And I know prosecutors, they really bit off more than they could chew. They probably expected the vast majority of people to plead. That didn't happen. But, you don't have to charge the entire conspiracy, or certainly not everything that's involved in the conspiracy. You can charge the shooting, you can charge whatever, you can charge discrete crimes and prosecute people for that. That's how we used to do it back in the day. And, there's been a lot of criticism of RICO by defense lawyers saying it's used in a lot of situations where it shouldn't be. And this may be one of those cases where it's an overbroad use of RICO. Now, obviously, I know the defense's position that this is all music related. It's not a criminal enterprise, but the question I have just procedurally, does trying a case like this make sense with this many defendants, this many witnesses, this much for a jury to unpack? And I think the answer to that is no, Josh, and that's why we're in the position we are.
Yeah. Well, something that's definitely gone wrong, because it was, I don't think anyone expected this to turn into what it's turned into. And it's really starting to be a dark mark on that prosecutorial office down there. It's really starting to become an embarrassment to them. But we will continue to follow it. It looks like easily going into next year if it doesn't stop before then. So stay tuned, folks. Let's move to New York, where the mayor of the city that never sleeps likely has additional anxieties keeping him awake at night after federal indictments on bribery charges alleging that he accepted, quote unquote, perks from foreign interest groups totaling over $100,000. Eric Adams, who has refused to resign as mayor of New York, pleaded not guilty to the charges, denying taking any action on behalf of the Turkish government in exchange for the benefits, which included free stays in opulent hotels, flights, and political donations. Adams' attorney didn't outright deny the perks given to Adams by the Turkish government, but claimed no quid pro quo took place. The litigator said in a news conference, congressmen get upgrades. They get corner suites. They get better tables at restaurants, adding, courtesies to politicians are not federal crimes. The federal government, however, disagreed, levying charges of wire fraud, bribery, and receiving campaign contributions from foreign nationals against Adams. This might not be the end of the problems facing Adams, as prosecutors have indicated they will continue to dig for any additional violations. Neama, I know you've been following this case closely. I've seen some of your commentary on it. What about this defense argument here that, listen, celebrities, sports figures, social media influencers, they all get perks. They get free meals, they get upgrades, they get all of these things. Nobody bats an eye. Is it different with politicians, or what's going on here?
Well, let's first talk about the case procedurally, because I want to contrast it with Young Thug. Here you have a defendant, right, who's alleged to have engaged in activity with co-conspirators. They're straw donors. But guess what? The feds in the Southern District of New York, they didn't charge everyone. They didn't charge dozens of people. They charged one person, the target of their investigation. So it's a much cleaner case. But let's get into the defense, like you said. So obviously, you have an elected official here, someone who's running for re-election next year. There's a whole PR political component of this as well. So when his lawyer, Spiro from Quinn Emanuel comes and, makes these types of statements, defense lawyers always do, but there's this whole political angle where they're talking to potential voters as well. So we gotta take all that with a grain of salt. The one thing, even though I always take the prosecution perspective, the one thing that I may agree with the defense, and one thing that they have is on the bribery charges. And we can thank our U.S. Supreme Court, because over the years, they have really limited when bribery can be charged, at least at the federal level. There has to be a quid pro quo, an exchange of value for an official act. Why is this important? Well, things like gratuities. Let's say you want to give someone a gift to curry favor with an elected official. Let's say the elected official doesn't declare that gift. That may be an ethics violation, but it's not necessarily a bribe under federal law. The Supreme Court has really limited it. So unless the prosecution can show that actual exchange of value for an official act, the defense may have a winning argument on bribery. Now, I still think the prosecution has a very strong case on the campaign finance violations, the straw donors, the failure to disclose some of these benefits, potential wire fraud, because there's some matching funds. But bribery is hard to prove at the federal level. That's why you see very few prosecutions, and the ones that are successfully the prosecution able to get convictions, sometimes those convictions are overturned on appeal.
Interesting point you're making there. I don't want to put you on the spot, but if I change the facts for you a little bit, tell me what your thoughts are. Had he just been upfront about all of this and declared all of this, hey, the Turkish government took me on this trip, they upgraded me, they put me in the presidential suite, all of this stuff, here's how much it all laid out in costs, and here's what was done for me. Do you think he wouldn't be in the same position that he is now, or is there something else at play here?
Well, I think there's a couple issues at play. One is the failure to disclose the gifts. There's some cover-ups, right? He tried to allegedly pay cash or pay lesser amounts than the value of the gifts. I think some of the challenges with the case, again, I'm just taking it from the defense perspective. I'm pro-prosecution, but the defense is saying, well, look, a lot of his freebies in terms of the upgraded business class tickets, the luxury stays in Turkish hotels, they happened when Adams was not even mayor, right? He was the bureau president of Brooklyn. And we're talking about this Turkish consulate in Manhattan. So really, did he even have control over the consulate in another part of the city. So there's a lot that's going on in terms of the timing and the geography that may affect the bribery part of the case. I think the stronger part of the case is really the campaign finance violations, because you have individuals who were apparently bundling or maybe even reimbursing people for their contributions. We know that this is important because under New York law, I believe there was a $2,000 max. So people were trying to give more than the max. So they'd funnel contributions through other donors. And importantly, New York had a matching funds program where, and sometimes it was an 8-to-1 match. So if someone gave $250, a small donor, that might get matched $2,000 by the government. So it's a way to get a lot more money pretty quickly. So there was this incentive. And of course, there is the allegation that's money is coming from foreign nationals, and that's a big no-no. That's unlawful under federal law and state law. So we'll see if they can prove that money was coming from Turkey and elsewhere to benefit Adams when he was a candidate.
Yeah. God, there's a lot at play here. Really, really not at all what it seems when you first hear about it. Last question on this. He has, and maybe not shockingly, but he has stubbornly refused to even discuss the idea of stepping down. Do you think, again, you talked about this at the beginning, this is kind of, there's a little more intricacy here when you're dealing with a politician. Do you think this is just kind of a PR position, or will that end up hurting him from a criminal standpoint, or no problem for him?
Well, we've seen a lot of elected officials deny and defend, right? And on both sides of the aisle, right? I mentioned Trump, but, Senator Menendez, this was his kind of MO. And, he successfully beat bribery charges once. Of course, he was convicted very recently this summer. But, there's always the argument that, any official acts, this is what elected officials do. We help our constituents when there's an issue. So the Turkish consulate needs a fire permit, then I'm going to talk to the fire commissioner and try to help out my constituents. So sometimes that argument carries the day. Elected officials have won with that. I expect that to be the same here, where Adams will use that argument. This wasn't a bribe. This was me helping folks out. And, as far as him being removed, I know the governor of New York can remove him. She hasn't said that she will yet. There's also some intricacy under New York law where there's an inability committee. If someone is unable to perform the functions under office, they can step in. But it doesn't appear that any of that's happening right now, although a lot of elected officials, including a lot of Democrats, have called for Adams to resign. I don't think he's going to do so.
Yeah, it's just going to get very, very messy before it gets any more clear. So thank you for all of that. I appreciate your insights, especially given your background as a former AUSA, but we're going to leave it there for now. Last case, which is out of Santa Fe, New Mexico, a film armor convicted of involuntary manslaughter will remain behind bars after an unsuccessful appeal in a district court. Hannah Gutierrez-Reed, who was convicted in the fatal on-set shooting of Halyna Hutchins, sought an appeal on the grounds that prosecutors suppressed evidence in their case against Alec Baldwin, whose charges were dismissed back in July. Baldwin's case was thrown out after a violation of the Brady rule when it was discovered that live rounds found on the set were turned into the sheriff's office, but the evidence was not filed under the same case number nor disclosed to Baldwin's legal team. Reed's defense is seeking an appeal on the same grounds. However, she won't be walking free anytime soon. Reed's defense has indicated they will continue to exhaust all options, appealing to a higher court. Help us unpack this, Neama. What happened with Baldwin's case, and why was that thrown out by the judge, and why do you think that same argument is not being entirely successful here?
Yeah, so let's talk about it. So actually, Baldwin's lawyer is the same lawyer who's representing Adams, and someone
he gets around.
Yeah, he gets around, and someone that I have active cases against. So I gotta just be transparent. But he does represent a lot of celebrities, and he did an outstanding job. So we all know, as prosecutors, you have to disclose certain categories of evidence. One of those being Brady evidence. So any evidence that tends to exonerate the defendant, you have an affirmative duty to disclose to the defense. And there's other categories as well, things that are required by statute and the impeachment evidence. The Brady evidence is very important, and it comes from a pretty important U.S. Supreme Court decision because it affects the defendant's constitutional right. So what happened in the Baldwin case is there was an individual who approached law enforcement, and that individual said, I have some evidence that the rounds that got on set, the live rounds, including the rounds that killed cinematographer Halyna Hutchins, may have come from another source, not armorer Hannah Gutierrez-Reed. Well, apparently, law enforcement got this evidence. They told prosecutors, and that evidence was not disclosed. Now, it doesn't matter whether it's true or not. It just may exonerate the defendant. So when the judge got wind of this, judge got upset and dismissed the case with prejudice with respect to Baldwin. That means it can't be refiled. But to answer your question, Josh, I really think the same logic applies to Hannah Gutierrez-Reed. I was surprised the judge did not dismiss or overturn her conviction as well, because at the end of the day, what exonerates Alec Baldwin should also potentially exonerate Hannah Gutierrez-Reed. So that was a disappointing decision. I think there's a very good chance that her lawyers are successful on appeal, but surprising to say the least, because I think the defendants are somewhat similarly situated, at least with respect to this evidence.
Yeah, it's again a very nuanced kind of argument taking place here. I'm wondering this, and see if you can fill this out with me. What's interesting in the Baldwin case is that the source of the bullets were not as important to the prosecution's case against Baldwin. Their claim against Baldwin was that his actions, the pointing of the gun, the pulling of the trigger, that was so unsafe alone that's what the reason why he was being criminally prosecuted. Now, I'm not saying I agree with much of that argument, but their argument didn't really matter how the bullets got into the gun. He never should have been pointing or pulling that trigger to begin with. What the judge found was that because the prosecution was aware that these bullets had been turned over, put it under a different case number, and didn't tell Baldwin's team that suppression of evidence that who knows how the defense could have used it was such a violation that she had to throw the case out. In Reed's case, it would seem like those bullets would be far more important to her defense, because the entire thing was about how did those bullets end up on set, and did she have anything to do with it, or could she have prevented it? But in her case, the question of the discovery violation seems to be more gray. Do you feel that might be what the judge is doing here? I'm just curious. Am I getting any of this right, or you feel like I'm missing the point?
No, you are. I agree. So obviously in Baldwin's case, the argument, there was a whole argument that as the producer who's responsible. I don't think that was necessarily a good argument, maybe in a civil case, but not necessarily criminal. It has to be your own conduct. But the argument was, look, even if Baldwin, you believed it was a cold gun, either Gutierrez-Reed or Assistant Director Dave Halls gave you the gun, told you it wasn't loaded, you shouldn't point it at another human being and pull the trigger, right? Baldwin denied pulling the trigger. The FBI ballistics report said it was. Now, you're right. Some of it's a timing issue, right? Obviously, law enforcement put it in a file, separate file, essentially hid it or didn't produce it before Baldwin's trial, and the timing was very different with respect to Hannah Gutierrez-Reed. So, is that... the timing of the discovery violation does matter. But I agree with you. When it comes to the live rounds, the argument at Gutierrez-Reed's trial was, she was high, she was drinking, she wasn't paying attention. She brought these live rounds on set herself. So certainly in terms of actual innocence, it does benefit Gutierrez-Reed more than Baldwin.
Yeah. Crazy case, crazy turn of circumstances. But again, she's going to try to see what she can't do about this with a higher court. And I agree with you. I with all this kind of prosecutorial misconduct, and I'll go as far as saying that, I think she at least deserves a very receptive ear from the appellate court. But in the meantime, that is all the time that we have today. Neama, thank you so much for coming on this week. Please tell us where people can find out more about you.
Of course, you can find me on all social media at Neama Rahmani, and my firm at West Coast Trial Lawyers. Thanks, Josh, for having me. Looking forward to being on again real soon.
Oh, absolutely. Thank you again. And I'm your host, Josh Ritter. You can find me on Instagram and Twitter at Joshua Ritter ESQ. And if you want to hear my thoughts and coverage on even more true crime cases, you can also check out my brand new YouTube channel, Courtroom Confidential. And of course, you can find all of our Sidebar episodes wherever you get your podcasts. And we want to hear from you. If you've got questions or comments you would like us to address, please tweet us your questions with the hashtag TCN Sidebar. And thank you for joining us at the True Crime News Sidebar.